You know, uh, every picture in television has to have some red in it. Sulaco, DeCrenza, Officer Lewis of the Pittsfield Police Department, and happy to report that, let's see, where did we leave off leading this to you? This is Walter A. Sarok, a liar for hire. He may be a liar pro bono in this case because they made such a mess of it, they might be trying to fix it up. And we are on page 82. Mr. Sarok, and she told you that she no longer wanted to be your sponsor because she was moving to Africa, is that correct? This is about Taibat Sulaco. And Glendora says, that is what she said. Mr. Sarok, you called her multiple times in attempts to convince her to renew her sponsorship, correct? Glendora, I did not. That is not correct. By that time, I had a nice new sponsor, a nice person who kept her word and wouldn't let Cablevision poison her. And I'd like to add, Mr. Sark, I think you mentioned it earlier, but do you know what extortion is? Extortion is making a person do something against his will by threatening him. Now, if you want me to go back, look in Black's dictionary, what extortion is, give me time. Mr. Sark, are you aware of whether there's a civil claim for extortion? Excuse me? Sarok, civil claims for extortion. Glendora, what are you saying? The court, all right, Mr. Sarok. Mr. Sarok, I'll withdraw the question. Well, there is a civil claim for extortion, and it's called civil recall, and it's Title 18, the United States Code, Section 1983. The court, I think we're getting a little... Mr. Sarok, I'll withdraw the question. Other than the claims you testified about today, there's no other claims that you have respect to any of the defendants. What did you say? Other than the claims that you testified about today, there's no other claims that you have with respect to any of the witnesses. I'm sorry, the defendants. Glendora, what are their names? Savarino, Sulaco, DeCrenza, and Officer Lewis. Glendora, DeCrenza and Lewis are out of it. That's the thing I would want to renew. Mr. Sark, and you have no further evidence other than that you presented today. Glendora, I didn't say that. I have evidence, Mr. Sark, aside from the receipts that were requested by the judge. I have audio tapes. Did you bring these today? Glendora, no. The court, audio tapes of what? Of Sulaco, of Cecilia, hanging up on me. Mr. Sark, but you didn't have them here today, correct? Glendora, and audio tapes of a lot of things. Well, Sark, you didn't have the lead defendant here today. The court, okay, why don't you have those here? Glendora, of my people that I talked to. Why did you do that? The court, okay, you're obviously familiar with the process because, what's that mean? Court, it means you've had a number of cases, whether or not they're directly related to this particular set of facts. Glendora, oh, dear judge. The court, hold on, let me finish. We're here for a trial today. Yeah, and why isn't the lead defendant here? And this is after, as you've indicated, this case has been dragged out a bit. And we're here for a trial, and we've been at it for about 2 hours, I believe. Glendora, I can tell you when we started. I made a note of it. The court, no need to check. The point is, I'm asking you, where is the evidence? Where are the videotapes or audio tapes that you're claiming you have of Miss Sulaco with the conversations? Why aren't they here for us to hear today? For one thing, you wouldn't listen to them. And Glendora, well, because Christine Savarino should be here. I should be cross-examining her and getting the information from her that will make you decide that I should be awarded $5,000 and $40 cost. The court, okay, but outside from that, you're indicating you have other evidence. You're telling me in response to Mr. Sarok's question that you indicated that you have audio tapes of Salako, correct? I really do not understand what's going on here. Well, court, I'm just trying to determine. Glendora, didn't I say that? The court, well, that's what, again, I'm trying to determine if there's evidence. I'm asking you, why isn't it here? The evidence is in the papers that I have handed into this court and that this judge was too lazy to read. That is the evidence. And this judge doesn't know what he's doing. The court, I'm just trying to determine, Glendora, didn't I say that? The court, well, that's what, again, I'm trying to determine if there's evidence I'm asking you, why isn't it here? Glendora, because this case has been handled so badly, mishandled so badly. The court, you have a box with various papers to it and so forth. My question is, why isn't that audio tape in that box, and why aren't we preparing to listen to it today? Well, first of all, I couldn't get it through security even if I had it. You could, anything of the kind. We have numerous things that come into this court, whether it's a Porsche seatbelt, as I had brought to the other day, that was checked downstairs and called for at the time it was needed. Glendora, oh, that's awful. The court, and we've had other things such as tainted water that's been checked downstairs and brought upstairs by a court officer that could have been able to be done. So, and again, I'm trying to get to the bottom of why, Glendora, why I respond to that, please. May I respond to that, please? Judge, go ahead. Glendora, want me to wait for you to finish? Judge, again, I'm prepared to give you every opportunity to prove your case. Oh yeah, except having the lead defendant there. And except for reading the case before you got to the bench. Glendora, but you didn't let me cross-examine Christine Savarino, and for purposes of appeal, I take exception to that. Judge, very good, that's on the record. And that will be something you can take up with the appellate term if necessary. Glendora, now I want to know, why wouldn't you let me bring in my tape recorder to record this? Why? There's no danger to it, Judge. Judge, my understanding is that in the state of New York it is not permissible to tape proceedings other than by official recorder. Glendora, why? Judge, I can't answer that. That's something you'll have to bring up with the OCA. That's the Office of Court Administration. Glendora, no, with Judith K., the official thing is very often tampered with, and the official thing is going to cost for this. It's going to cost over $1,000. Where am I going to get the money to pay $1,000 to appeal this racket? Good for you, Glendora. Judge, again, I think you're getting ahead of yourself. I don't know that you're going to have to appeal it. But in the event that you need to appeal it, you'll be in the same position that every other litigant is in these situations. And that's the wrong situation to be in, let me tell you. Litigants shouldn't be put into that situation. Which is why it's always a good idea to be very succinct and so forth. I have to tell my case. Glendora, I would say so, Judge Wood. If you will look at West Publishing and just put up the name Glendora, you will see 8 pages of approximately 20 lawsuits each that I have brought under the name Glendora, but that isn't all of them because West has never been able to keep up with my lawsuits. Court, okay. Glendora, okay. The answer to your question is, where is that evidence? It is in my house, and I'd like to say again on page 9, the small claim court tells us to put the full and complete legal name and that I want of Christine Savarino for service of process, among other things. Judge, okay, you made your point on this, and I will decide that. And he never did. That's a broken promise, so that this case is really still pending, because there's a motion pending before the court. I said I'd reserve the decision on that and decide that as part of the decision. Well, you didn't. Glendora, I wanted also to tell Christine that even though we are antagonists, I have prayed for Christine for a year, practically every day, and for Cecilia and for Sarok and for Tybot. Judge, I'm sure they all appreciate that. All right, at this juncture, I'm going to stop those proceedings momentarily. What? Judge, just momentarily, I have a young lady who's waiting for a post-eviction hearing, and she's been waiting patiently for almost an hour. And I want to get her. It will be very brief. You can stay where you are if you'd like to get up and stretch your legs. You may do so. Court officer, it's going to be quick, so don't go far. Judge, recalling Glendora versus Savarino, Sulaco, DeCrenzer, and Officer Lewis. Okay, Mr. Sarok, were there any further questions? Sarok, I just have a few more, very few. The court, okay. Sarok, are you aware of any personal benefit that Ms. Savarino has received by, as you say, poisoning your sponsors? Glendora, yes, for personal qualifications and gratification, spite and malice. Mr. Sarok, anything else? Glendora, if she were here, I'd ask her that. Mr. Sarok, anything else? Glendora, no, wait just a second. I understand if she personally doing it, or as Judge Wood might have suggested, does it come from the hierarchy in Nassau County? No, that's what Ms. Savarino should be here to answer these questions. So my answer to that is, I wanted to also ask her if she was under any psychological, psychiatric kind of counseling, that she does these strange things, not only chasing my sponsors, but why didn't she just return my videotapes, and why did she send the videotapes from Wappingers down to Harrison, and it's like sending my Yonkers tapes up to Peekskill. Why did she do that? Mr. Sarok, has Miss Savarino ever has Miss Savarino ever promised to reimburse you for the time expended in finding your sponsors? Glendora, say it again, please. Sarok, had she ever agreed to pay for time and energy you've expended in locating your sponsors? Glendora, has she personally? Mr. Sarok, yes. Glendora, ever agreed to pay to reimburse me for the time and money finding sponsors? Sarok, correct. That's a ridiculous question. My answer is no. Mr. Sarok, you've elongated this case. We've got to go 100 miles yet, 125 miles, and this is the second time that we've been down here, and it's all your fault. If you hadn't confused the court, Sarok, are there any other expenses that you're seeking reimbursement for, other than those you mentioned to the judge earlier? Glendora, and they would be what? Mr. Sarok, I'm asking you, are there any other expenses you're seeking? Glendora, what are these other ones that have been mentioned to the judge? Mr. Sarok, answer my question. Glendora, I can't answer your question until I know what you're talking about. Mr. Sarok, you don't remember what you told the judge your damages were? That's a vague question. Court, okay, let me interject. Okay, we are on page 90. To go up to 125. Glendora, thank you. Court, you're the plaintiff here. You have outlined the damages that you feel you're entitled to. All Mr. Sarok is asking you is, if you've forgotten anything, are there any other damages that you're entitled to from these defendants, other than what you've already outlined? It's not his job to restate what you've already stated. Glendora, I reserve on that. No, you need to answer the question. I answered it. I reserve. No, I'm going to take it that is a no. Glendora, I take exception to that for purposes of appeal. The court, so noted. Sarah, Your Honor, I have no further questions. Yeah, he'll be back 5 and 6 more times. Glendora, it just says that on any legal paper, and you say any further relief that is just. What I mean by that is, on any other legal paper, I have said what I wanted was $5,000 damages and any further relief that is just and proper. The court, right, but this is a trial and this is your opportunity to provide documents, and I've granted you 2 weeks to provide receipts. But my dear Judge Wood, I have provided those documents and they are in the papers that you haven't had time to read and that you haven't done your homework. And you don't have a lead defendant here. This is hardly a trial. And I've granted you 2 weeks to provide receipts, but that's the only thing I'm giving either side any. What you should have done is granted me the $5,000 for 2 hours and 55 minutes ago. Opportunity to do other than that's being done here, while under oath with the opportunity to cross-examine. I would say we are not under oath. You did a sloppy job of that. A gang under oath. You should go to each litigant and say, do you swear to tell the truth, the whole truth, and nothing but the truth? While under oath with the opportunity to cross-examine. Well, Christine isn't here to examine. Glendora, is he asking me, have I fully stated the damages that I think I'm entitled to? Is that what he's asking me? Essentially, yes. Well, then what else? What other condition is it? The court, it's the question, and you need to answer his question, and I'll give you another opportunity to answer it other than you reserve, other than what you've stated here today. Are there any other damages that you're seeking of these defendants? Glendora, no. And I still think that's a dumb question, and if there was, I would have stated them. No, I have no other damages than what I've stated. The court, very good. Okay, that's all we were trying to get to. Any other questions? Sarah, no other questions. The court, okay, but watch Sarah come back again. I want to thank you. You've been very patient, Glendora said to Wood, I appreciate that. Thank you. Do you have anything else you need to, any other documents you want marked as evidence? Do you want to take the opportunity to go through your box? Glendora, yes. These are originals now. The court, well, you're in the same position that all the litigants that appear before me in this court are. We take the originals. We mark them and then we return them to you with the decision, unless they're too bulky. Hold on, unless they're so bulky that you would need to come and pick them up, which is the case with the young lady with the Porsche seatbelt that's sitting on my desk in a box. I wouldn't trust them with the originals. They've lost. The first time I filed this case, they lost it. The first time I filed this case, they lost the $20 filing fee. I wouldn't trust them with the originals. Glendora, I commiserate. No. As a matter of fact, the documents that I was thinking I would leave you were the refusals of by Christine Savarino, which is a question I want to ask her. And Mr. Sarah, why did you refuse legal papers? And those are now in your record. I have sent them to Judge Doran. Why should I hand in my originals when sitting right there on the desk? Sitting right there on the desk is excuse me, I have to change the light. We've got a burn. Okay. They're sitting right on his desk, and he wants me to give up my originals when he has the copies of them right in the record. Read the record. Sarah, Your Honor, I don't know if this should be addressed, but she's represented by counsel and papers were sent to me that were sent to Miss Savarino. Yes. You've got a copy of everything. The court, okay, but again, Sarah, I'd ask that she refrain from speaking with my clients over the course of the case. Glendora, oh, now, just a minute. To that I say absolutely no, and you give me your statutory authority. Where did you ever get that idea? Judge, all right, hold on. We're getting again far afield here. I want to be clear because I want your record and I want everyone to have a clean record for possible appeal by either side. Now, I do not have any evidence from the plaintiff at this point. Yes, you do. It's on the desk in front of you and it's 2 inches, which you acknowledged when you came in here. I have nothing other than your testimony, ma'am. If you want me to look at receipts or if you've referred to your prior papers, but those are not evidence. So if you want, why aren't they evidence? Why aren't they evidence? Glendora, what did you say? Judge Wood, any prior papers, any motion papers, or anything of that kind are not in evidence in this case. Why aren't they? They're on the desk, on the bench in front of you. The court, if you want to have receipts and so forth that you've referred to, I again have indicated you have 2 weeks to provide your receipts. But your papers back and forth before this case appeared today, that's not in evidence. None of it is. Why not? And you're tampering with the evidence. Glendora, okay, I wanted to bring into evidence, please, the papers that I sent this court of Christine Savarino's refusal of my legal papers. The court, okay, do you have that? Yes. The court, do you have a copy you can hand up to me? Glendora, well, they're originals, and they're already in this record. I don't see why you're excluding the record of what's happened before. No, I don't see that why, and I never will see that why. Judge Wood, it's not a question of excluding it, it's a question of you need to provide the evidence. Glendora, it has been provided. The court, okay, Glendora, it's in the record. It's a matter of record. Judge Wood, what you've provided is, again, I haven't gone through page by page this 2-inch record, and you should have. I do not want these. If I give these to Court Officer Joseph here, am I going to get them back tonight? Judge Wood, if they're going into evidence, no, you will not get them back tonight. You'll get them back again depending on the volume of what you had hand me. You'll either be required to come pick it up yourself, which may in fact be the safest thing to do. I'll say it is for this court. Glendora, oh, I'm going to make a motion to you, and I'll make it in writing, that you looked at these refusals that are in the record before today. They've been in the record for the past month. I'm going to make a motion for that. Okay, again, I'm telling you that there are certain terms of ardent that you're throwing around that are not the same meaning that I, as a judge, take them to be the record that will go up on appeal, and the record of this trial require evidence to be produced in the trial. Yeah, so where's Christine's evidence? At the trial today, I'm asking you for evidence. Again, I'm giving you 2 weeks to give me receipts, but if there are other things that you want me to look at in making the decision, you need to give those to me. They have been given to you. Now, I sent him, in addition to those receipts, about 15 letters by Christine Savarino in her own hand, writing to my sponsors and admitting that she had telephoned them and saying that she was not going to accept their application. Now, even if I had provided more evidence, that would have been his reaction. He would not have looked at it, and he would not have ruled in the favor of justice. Glendora, this case has not been bifurcated. I think you're wrong. Not to look at, you're going to read it, you said. Judge Wood, I'm only going to look at whatever is relevant. All these motion pictures have been decided. Judge Doran decided all these things, but in that there is the evidence that he's seeking. And he's just being lazy. Judge Doran has decided all these things. He's wrong about this. He still has to read the evidence that's in my papers. So you need to provide to me anything that's in your papers. This is trickery. This is denial of material fact. This is Criminal Code 18, Title 18, United States Code 1001. Denial of material fact. So that I can mark it into evidence. Now, I'm even willing to take a copy as long as you have the originals here so that counsel can examine them and compare them. Glendora, you have a copy. I should have said, I incorporate all of the papers that I have submitted to this court. As if fully stated herein. Herein I incorporate all of the papers that I've submitted to this court as if fully stated herein right now. And there's no reason I should do that because they are already in the court as evidence. Glendora, I might have a copy of the court. I'm not trying to make it difficult on you. Oh, yes, you are. I just want to make sure that everything is clear. Well, it is clear. You have the papers, you have the evidence, do your homework, read it. Glendora, oh no, you have not made it difficult, but I'm very disappointed in small claims in this court. It is not supposed to be like this. It's supposed to be a simplified litigation. Now here is, as I say, I was very pleased with the order. Here, officer, there's one. Oh, and this is a good one. Who to sue? Judge Wood, okay, I've got a pink and a green cover page. Apparently first notice and second notice, dated August the 25th and dated August the 31st of 2006. One indicating refused post office, the other doesn't indicate anything. That'll be plaintiffs 1 and 2. The third thing I've been handed in appears to be the second notice that indicates refused. That'll be plaintiffs 3 and 4. Is the second notice to the court regarding Savarino's refusal. That'll be plaintiffs 3 and 4. And he said that he would return them. He never returned them. They never came back to me. Glendora, that's when I demanded that we should have a trial. The court, okay, and you've had it today. Glendora, thank you. Well, right now, I don't say thank you. Judge Wasara, Your Honor, our objection, as I've already basically stated, is first of all, it's just evidence. It's not evidence. Second of all, everything I just saw, I was served with as counsel for Miss Savarino, and he hasn't proved that yet. So it has been received and service was effectuated. Judge Wood, all right. So you're vindicated. You've waived jurisdictional defense of not having been served. You're indicating on the record that this Savarino has been served. Mr. Sarok, correct. Judge Wood, here representing her interests here today. Sarok, correct. But Glendora, Judge, why did Savarino refuse those papers? Judge Wood, I can't answer that. But her counsel has acknowledged that she has been served with them. So, all right, counsel, why don't you answer why she refused the paper? Well, I'll answer it because she's scared stiff, because she's done wrong, because she's guilty, because she's a fugitive and she's running away. Glendora, but her counsel can't answer. That's why. Judge Wood, well, he's answered in as much as he's entitled to be here on her behalf. He's waived the jurisdictional defenses. It's She is effectively in the courtroom today for the purposes of answering the claims you have. And I'm marking these exhibits